we have mostly wins to discuss this year from a civil liberties perspective. So let's get into it. We're going to begin with an immigration case. That's always a hot topic. This was a case that came up in Arizona. Mike drew the short straw or the long straw, depending on one's point of view, and gets to go first. So Arizona v. U.S., what happened and what was the result?
This case, Dan, was the result of the United States government seeking injunctive relief, and that's going to be important as we talk about the case. Basically, what the federal government argued was that the attempt by the state of Arizona to enact legislation that moved into the area of immigration law, that federal law should preempt Arizona's attempts to do that. And we know that this has been a very hotly debated issue, a very sensitive issue all over the United States, and especially in the Southwest and in Arizona. What happened was this case, the federal government challenged what Arizona called the Support of Our Law Enforcement in Safe Neighborhoods Act. And the purpose of that state law was to discourage and deter the unlawful entry and presence of aliens and economic activity by persons unlawfully present in the United States. There were 4 provisions of that law that were challenged by way of injunctive relief. In other words, by injunctive relief meaning that on their face, these 4 provisions ought to be preempted by federal law because immigration law is within the province of the federal government. Section 3 was one of the 4 sections that was challenged. That section made failure to comply with federal alien registration requirements a state misdemeanor. Section 5C made it a misdemeanor for an unauthorized alien to seek or engage in work in the state. Section 6 authorized police officers to arrest without a warrant a person the officer has probable cause to believe has committed any public offense that makes that person removable from the United States. And lastly, Section 2B provides that an officer who conducts a stop, detention, or arrest must, in some circumstances, make efforts to verify the person's immigration status with the federal government. Now, the good news is the first 3 provisions that I mentioned were all struck down by the court.
For jurisdictional reasons.
For jurisdictional reasons.
Meaning that they addressed federal
That's correct.
law, not the states don't have standards.
That is correct. The somewhat bad news is that Section 2B, which was the one that allowed officers to conduct a stop, detention, or arrest, must in some circumstances make efforts to verify the person's immigration status with the federal government. The court declined to address that, again, in the context of injunctive relief, where you didn't have live people affected by this litigating these issues. What the court said is that there is a basic uncertainty about what the law means and how it will be enforced. In other words, there was no controversy before the court between a real live person and authorities in the state of Arizona to state that this provision of law did not meet constitutional muster.
So it hadn't happened yet.
That's correct.
That event, the 4th event, had not occurred.
That's correct.
Therefore.
And so what we know is that the ACLU and other organizations are actively involved in both public policy efforts to address that provision of the law, and there is also litigation wending its way through the courts that would address that. When that will come before a court or the Supreme Court of the United States, we don't know. So it's mostly a win, but there is one part that was left up in the air, so to speak.